From an asset protection point of view, a corporate trustee is critical. What it does is it separates the legal ownership of particular assets which are held by a trust from the assets and the liabilities of the people who are interested in the trust. In many cases, you'll find that the directors and/or shareholders of a company are at risk, and that means that they are at risk of being sued by particular creditors or groups of creditors. If there are assets held in a trust which has a corporate trustee, it further separates the divide between a person's own liability, whether it be as a director or as a shareholder or any other capacity, from the liabilities of the trustee and therefore the trust. And so creditors in that situation can or may be able to sue the individual who is either director, shareholder, other capacity, but not the company, unless the liability has been undertaken by that company in its capacity as trustee of those trust assets. And so the trust assets are protected from those creditors by that separation. It's critical, particularly for trading entities, that they have a corporate trustee if they're operating through a trust, or if they are operating otherwise than through a trust, but have assets held outside of the business in a trust structure. The separation becomes more critical because, as a trading entity, the likelihood that you will be sued by a creditor or the ATO as a creditor are increased. That's just the nature of business. It's a commercial enterprise and therefore there is commercial risk. Where trusts are passive investors, the risk is somewhat lower, but the risk is still there.